We're going to cover what is asset protection, when, how, and why can you use asset protection for yourself, your business, and for your legacy you leave to loved ones. So an inheritance that you might leave to someone. Think about future ex-sons-in-law or future ex-daughters-in-law. That is a form of asset protection. And what role do LLCs, partnerships, and corporations play? We're going to talk about piercing the corporate veil. This is a very important concept in asset protection, as well as business succession planning and exit strategies, because business succession is also a form of asset protection. We'll talk about what happens if you're a partner with someone in a business and that partner dies, goes through bankruptcy, gets divorced, whatever it might be. That's something that does happen and something that should be addressed in your business in order to protect the underlying assets, and how all this works, certainly with incapacity and death. So I'm a lawyer. I'm Jim Cunningham. This is not legal advice. Okay. I'm talking about a bunch of stuff. When I say you, this is not, there's no attorney-client privilege here. It's very important to understand this is something you absolutely want to get competent legal advice for. It's something that everything we're talking about here, we handle at our firm. If you're watching this on YouTube, please subscribe to our YouTube channel, and you can click the share button and share that with your friends. And we post content about every Thursday at 6 p.m. So that pops up, will pop up in your YouTube feed. We have office locations in Northern and Southern California, and we are up to 16 lawyers now, all dedicated to estate planning, trust, real estate, and business matters. I'm Jim Cunningham. I'm the CEO and partner at Cunningham Legal. I have 30 years of experience. I'm a certified specialist in estate planning, trust, and probate law, securities, and insurance licensed, and a pilot single engine land, not current, but a pilot. So what is asset protection, right? Let's start with the basics. Well, it is a component of financial planning. So you can think of asset protection as this component of planning your finances, because you have your life, and a judge can take your liberty away and throw you away in jail. A creditor can take your assets. Those are like the two things that can happen in the world externally, right? So take your assets or take your liberty. So what we're talking about is having this be a part of financial planning. And this is designed to protect assets from creditor claims. So this is going to be third parties. These are going to be people in the outside world who say, hey, you owe me money and I want to come and collect it. And you say, well, no, I've got this financial planning structure, which is an asset protection structure in place. So Mr. Creditor or Ms. Creditor, you're not going to get money from those protected assets. And individuals and business entities use asset protection techniques to limit creditor access to certain valuable assets, certainly while operating within the bounds of debtor-creditor law. This is very important because there are boundaries of debtor-creditor law, and you have to do it right. Otherwise, you won't have the protection. So if you step outside the bounds of those legal constraints, that does open up the possibility of piercing the corporate veil, and we're going to talk about that. So let's look at an example here. I'll call it Rancho Fuego. Fuego, by the way, is the Spanish word for fire. I think you know where this might be going. Oscar owns the shares of an LLC that owns a ranch called Rancho Fuego. So Oscar has shares in an LLC. The owner of the dirt, the owner of the ranch, is an LLC. Romeo, the ranch hand, is clearing brush using a controlled burn. Unfortunately, the burn gets out of hand and jumps to an adjacent ranch, and burning structures and causing other damage. The neighbor successfully sues and goes after the LLC, Rancho Fuego, right? The shares owned by Oscar. Oscar's other assets are not available. So it's very important to understand, in the operation of the business, this Rancho Fuego LLC, if a liability arises, that liability is contained inside of the LLC. That is something we call inside liability, and we'll talk about that quite a bit later. So just understand, when assets are properly in an LLC, that limits the liability to the assets of the LLC. Well, what is not asset protection? And this is very, very important. So if you're watching this and the liability, that fire's already happened, that whatever it is, that lawsuit's already been filed, that claim has already arisen, this is not something you do after you get sued. This is not something after the claim arises. It's like your house being on fire, and then, that's not the time to buy fire insurance. They will exclude that coverage. Asset protection is not insurance. And this is another important distinction. Asset insurance is designed to pay off a creditor instead of the creditor taking your assets. So, you get in a car accident, The insurance company pays the person who's injured. You're not paying that money, but that person's still getting those assets, but they're coming from the insurance company. But remember, insurance has a three-pronged test. So a lot of people say, well, I don't need asset protection because I have insurance. Be careful with this, all right? Because insurance is constrained by time. So a policy typically covers a period of time, let's say a year. There are policy limits, right? It's the maximum amount that the insurance company is going to pay. This is not about protecting your assets. This is about insuring a risk, and then coverage. So insurance companies will not pay out on a policy if the event is not covered under the terms of the policy. And I will tell you, we had an attorney work at our firm years ago. He said, I used to work at an insurance defense firm, and every day I would get something on my desk, and it was, a letter from the insurance company that said, here's a claim. This is the policy owner. How can we get out of paying this claim? I mean, this is kind of how insurance companies operate, right? If you don't pay your premium, you get canceled. But when it comes time to make a claim, it's a big hassle. So very important to understand, a living trust provides no creditor protection for the person creating the living trust. So if I create a living trust, that's no creditor protection against my potential creditors. Now that's a little bit different. If I pass away and leave those assets to my children, we can have creditor protection in a living trust, but it's not going to be for me. So let's look at Charlie's car accident. Alpha and Bravo have a son, Charlie. Charlie's driving a car owned by Alpha and Bravo. This is probably pretty common. This may be you. Charlie's in an accident, and guess what? It's Charlie's fault. Alpha and Bravo have a $500,000 auto policy and a $3 million umbrella policy. Now, what an umbrella policy is, it's a policy that says, hey, if there's an accident on that 500,000 and the damages go over 500, that umbrella policy kicks in up to 3 million. So after trial, the damages are determined to be $1 million. The auto policy pays the first 500, and then the umbrella policy pays the next 5, and that's it. So the umbrella carrier is not paying another 2.5 million or whatever it is. The creditor gets their money. The insurance company pays it. If you don't have umbrella coverage, I would recommend you consider looking at it. Now, again, I'm not going to make a recommendation that you buy it, but certainly take a look at it, because that's something that many auto policies are capped at 500, and oftentimes the damages are over that. And so you have this gap in coverage. So for most of our clients, we suggest that they look at the umbrella policy. It's really not that expensive. So how can companies use asset protection, specifically companies? So companies can take a variety of forms. One is a sole proprietorship. That's, if someone has a lawnmower and a pickup truck and they're mowing people's lawns and getting paid by Venmo or cash, and you don't have to set up a corporation that goes on your Schedule C on your 1040. That's a sole proprietorship. I'm out there in the world, one person out there in the world doing something. If two people form a partnership, maybe one person brings in the lawnmower, the other brings in the truck, and they say, we're going to split. We're going to both work in the business, and we're going to split it 50-50. That is a general partnership. General partners have unlimited liability for the acts or omissions of the partnership itself. So if one guy's mowing the lawn and damages, somebody or a thing, then that other partner is liable as well. So that's a general partnership. A limited partnership is kind of the precursor to the LLC. General partners have unlimited liability. Limited partners, of course, have limited liability and have asset protection. So when you hear limited, that's going to be, it's going to trigger asset protection language. A corporation, it can be an S corporation or a C corporation, depending on how they're taxed. A corporation has to have bylaws, it has to have regular meetings, and it has to have significant formalities. Corporations have been around for about 400 years in the world, and they used to require an act of parliament to get a corporation, and now you can just go online and in any state and organize a corporation. So S and C has to do with taxes. Typically, operating businesses are going to have a corporation, and then there's an LLC. So the LLC kind of replaced the limited partnership, and an LLC can have different forms. An LLC can be what is called a disregarded entity, which means you might pay or you might file a state tax return, income tax return, but no federal return, and all that income and expense and everything is reported on your federal return if the LLC is a disregarded entity. So a little bit like a sole proprietorship. An LLC can also be taxed as a partnership. Now, one advantage of being taxed as a partnership is you file a separate income tax return of Form 1065. Those tend to get audited less than individual returns. So corporate returns typically are audited 20 times less than an individual return, They typically involve a CPA. You're filing a balance sheet with the return. So those tend to be audited less. But that partnership structure in an LLC is typically, you're going to see that if people own real estate. So if two or more people own an interest in an LLC, that's typically going to be taxed as a partnership if it's real estate or other capital assets. And then your LLC can also be taxed as an S or a C corporation. The default is a partnership. So if you do nothing, you're going to be taxed as a partnership or disregarded entity, but you really have to kind of opt into the S or the C corp. We do frequently see LLCs taxed as an S corp. So a little bit of background on different structures of business. So why is it important to have an entity in the first place? Can't you just be a general partnership or a disregarded or a sole proprietorship? Well, Alpha and Bravo are general partners in a business that makes ube flavored ice cream. If you've never had it, it's really good. It's I think it's a sweet potato from the Philippines or something, but it doesn't sound like it would be good, but it is good. Echo, the employee, is driving a delivery van and is rear-ended by a drunk driver, pushing Echo into a van carrying 10 physicians, all of whom become paralyzed. So this is sort of the classic law school hypothetical. Even though Echo is deemed only 1% at fault, this is very important to understand about liability. Even though Echo is deemed to be 1% at fault, Echo and Alpha and Bravo, because Echo is employed by Alpha and Bravo, so that's respondeat superior. We're going to cover that in a couple of slides. All of them are jointly and severally liable for the special damages. Now, general damages, you can think of pain and suffering. Special damages are things like medical coverage. While their medical bills for these 10 physicians will exceed $300 million, so Alpha and Bravo are each 100% responsible. So if Alpha has a ton of money, Bravo has no money, Echo has nothing, right? Alpha could be responsible entirely for that, and that's called joint and several liability, unless they have an entity. So this is, again, I mentioned the typically when you have an operating business, you're looking at a corporation. So if Alpha and Bravo had created Yummy Ube Inc. and Echo is an employee of Yummy Ube Inc., delivering the ube flavored ice cream in a van leased by Yummy Ube Inc., right? You see where I'm going with this. Echo is rear-ended by a drunk driver who pushes Echo into a van, injuring the 10 physicians. And what happens is Alpha and Bravo are no longer personally liable. So the liability is contained in that business. So this is very important to understand, is certainly those 10 physicians could come after the assets of this business, but that's all they're going to come at. That's all they're going to get. They're not going to get the personal assets of Alpha and Bravo. So if you have a business and you're worried about liability, you really should consider having an entity, whether it's a corporation or an LLC. That's something certainly that, one-on-one with a lawyer, and that's something we can help you out at our firm one-on-one with. But something very important if you're in business, you really should be looking at an entity. Let's talk about piercing the corporate veil. So first of all, what is the corporate veil? I always think of like a mantilla, and I studied in Spain. It's the thing a woman would wear over her face in church. That's a veil, right? It's this thing that you can kind of see through. And can you pierce that? Can you disregard the corporate veil and go after the underlying assets? So the corporate veil establishes the corporation as a separate legal entity. So it's distinct from the people who own it, operate it, manage it. It gives liability protection for the shareholders, right? The investors. It gives liability protection for the directors and the officers. It requires proper formation and maintenance. So we're going to cover that in another slide. But to maintain the shield, you have to do all the things that you need to do. And I would say the biggest offense is using a corporate account. And by the way, when I say corporate, I'm talking LLC, partnership, whatever it is, this entity. It's using an entity's assets, frankly, as your own. It's your own personal piggy bank. That is the single biggest threat, or not paying your franchise tax fees to California, and we'll cover that. So a corporate veil is this legal concept that separates the personality of a corporation from the personalities of the shareholders. And again, it applies to corporations, LLCs, limited partnerships. Does not apply to general partnerships because general partners are liable. It protects the shareholders from being personally liable. And this is why Oscar, in the fire example, Rancho Fuego, this is why Oscar was not personally liable. So what about piercing the corporate veil? So piercing the corporate veil is when a court sets aside the limited liability of a shareholder, manager, officer, or director, and then holds these people, these investors, the shareholders, personally liable for the debts, acts, or omissions of the entity, right? The corporate entity. And again, when I say corporate, it's not necessarily a corporation. It can be a little confusing. corporate entity does include LLC and limited partnership. It is most common in close corporations or close LLCs, meaning it's more common if you're the sole shareholder in a corporation and you're, buying groceries off your corporate card, right? And running all those expenses through your business and just and rating the corporation for personal expenses. That, I would say, that's pretty dangerous. So you want to definitely have your personal expenses be personal and your business expenses be business, and keep the two separate. Again, state laws vary, and courts, I will say that courts have a very strong presumption against piercing the corporate veil if you follow all the corporate formalities, if you follow all the rules. By the way, this is not a do-it-yourself project, and there's a lot of information online there. A lot of people say, "Hey, I watch your videos, and I'm really a self-starter and a learner." Hey, that's great. I'm always going to be a pilot, but I'm not a current pilot. I know how planes work. I know generally how to repair a plane. I'm not going to repair my own plane. That's nuts. It's existential, right? If I mess up, I'm dead. In this sense, it's kind of the same with this corporate. If you have something to protect, it makes sense to you to expend some time, effort, attention, and resources, including legal fees, right, to make sure that your corporate veil is not pierced. So, when do courts pierce the corporate veil? I would say this is serious misconduct. So the courts do understand the benefits of limited liability because it's good for the economic development. It encourages public markets, right? I mean, imagine if you did not have limited liability, no one would buy a stock in a company, right? If they're like, well, if I'm going to be on the hook if this company goes under, not only do I lose my investment, but I might lose my personal assets, there would be no stock market. So this includes, again, personal use of corporate assets. So it also includes undercapitalization. So setting up an LLC, but really not putting anything in it, or really not having any assets in it and saying, oh yeah, I have this LLC, but I haven't set up a bank account. I haven't put anything in it. Yeah, a court's going to be more inclined to disregard it. Very important. If you're in California, a court can pierce the corporate veil if the corporation fails to pay its franchise taxes or file required reports. So California has a biennial, which means every 2-year reporting requirement. And you got to pay the fee. And a lot of people lose their mind when they go, I got to pay $800 a year minimum franchise tax for these LLCs. If you're a California resident and you have an out-of-state LLC and you're managing the LLC, California says you need to pay that $800 minimum franchise tax. So very important not to ignore that, because California very well may ignore the existence of an entity if you're not paying the taxes, right? That's kind of the bottom line. It makes the directors, shareholders, and everyone involved personally liable. So let's look at an example. Alpha and Bravo use Yummy Ube Inc. Remember Alpha and Bravo? Let's say they didn't have a car wreck, or maybe they did. I don't know. And they're doing really well. They're selling lots of Ube. It's now, they go in Shark Tank and they're selling the Ube. They find and buy a luxury yacht in their own name for personal use, blatantly ignoring the separation between them and the business's finances. And facing a lawsuit, the court pierces the corporate veil, targeting Alpha and Bravo's personal and business assets for seizure. So they just yank money out and they ignore all the corporate formalities, and they just wire the money out, take title of the vessel in their own name. Kind of that sort of personal use of these of corporate funds. So they'll pierce the corporate veil. When, how, and why can you use asset protection for yourself? Well, when is it too late? It must be before the liability arises, right? Otherwise, any transfer can be deemed by a judge to be a fraudulent transfer or voidable transfer. And if you're an attorney watching this, you are probably aware that there was a recent case that held the lawyer liable for 3 times the debt of the client, right? This was the person seeking to hide their assets. So this has really had a very, I would say, an extreme chilling effect in the asset protection community, where lawyers are much more cognizant and paying much closer attention. If you already have that liability, if someone's coming after you to collect money, you're not going to find a lawyer who knows what they're doing who's going to try and help you hide that, because the lawyer becomes personally liable. So that's not something our firm does. This is something you have to set up ahead of time. So let's talk about outside liability versus inside liability. So this is a very, very important concept. So liability, generally, there are 2 hemispheres, right? It's sort of like we have an Eastern and a Western hemisphere and a Northern and a Southern hemisphere on the planet Earth. We divide all liability into outside and inside liability. Outside liability is best described as personal liability. You get in a car wreck, someone's coming after your assets, right? This is something you do personally. Inside liability is best described as a business liability, a liability that arises from business activity. So remember the Rancho Fuego, you're clearing brush. Oscar wasn't doing the work. He wasn't clearing the brush. He wasn't burning anything. It was an agent of his, an employee that was doing that. That would be considered inside liability. So let's look at outside liability. Alpha and Bravo have a son, Charlie. Charlie's driving a car and gets in an accident. It's Charlie's fault. Does it sound familiar? Even though Alpha and Bravo aren't driving, each of Alpha, Bravo, and Charlie is personally liable. And so the injured party can seek recovery from the personal assets of Alpha, Bravo, and Charlie. So that's outside liability. And what a lot of people try to do, this is also called reverse piercing of the corporate veil. I have a personal judgment against Alpha. I'm going to go out into the world and see what assets Alpha owns. You own shares in a closely held corporation. You own shares in an LLC. I'm going to try and seize those assets to satisfy a judgment. And we'll talk about that. Inside liabilities, again, the Rancho Fuego. Romeo the ranch hand's clearing brush. It gets out of hand. Again, this is the inside liability. Now, how do we protect assets from outside liability? So this is if you do something or your kid does something that generates a liability. So there are two big forks in the road. One is the Wyoming Close LLC, and then we'll talk about a domestic asset protection trust, how that works, and the charging order. So when an LLC is organized under the laws of Wyoming, and the operating agreement contains some very specific, I would say, magical provisions. A personal creditor cannot break into a Wyoming Close LLC to satisfy a judgment. The creditor's sole remedy is what is called a charging order. This order is a relatively weak order, and I'll explain why it's a weak order. And the benefits do extend to single member LLCs as well. So you set up just a regular LLC in Wyoming. There's no separate filing for a close LLC. All the good stuff, all the magic happens in the operating agreement. Now, this is just a little tip. I have met with a lot of people who do this online. They may even go to, typically it's going to be non-lawyer service providers. And they say, oh, I have a Wyoming LLC. My assets are protected. We met with a client a few months ago. I read the LLC. I said, well, it's not a close LLC, because your operating agreement doesn't contain these sort of magical terms that give you creditor protection. So give you that charging order protection. So a charging order, what is a charging order? A charging order is a court-authorized lien brought by a creditor on distributions made from a Wyoming Close LLC, or not made from a Wyoming Close LLC, as you'll see. The debtor, this is very important. The debtor, the person who owes the money, probably you, right, in this example, still stays on as a member of the LLC. So we're going to look at California's example. They can actually foreclose on your shares of the LLC, right? So this is why California is terrible for asset protection, frankly, in a lot of ways. There's one exception. The charging order is limited to the amount of the judgment, and it's kind of like a garnishment of wages. So charging order is kind of confusing, right? It is, if you hear that, you're like, well, what does that mean? Think of it as like a garnishment of wages. So as you get those wages, as you're working, as you're a W-2 earner, someone can come into your bank account and yank those out of your account. So similarly, if you're the member of the LLC and you own those shares of the LLC, that creditor, once a distribution is made from the LLC, can take that money out of your account. So obviously the creditor, the creditor's not becoming a member of the LLC. So who controls when the assets are distributed? Who controls when money's distributed? Well, the debtor, maybe not the debtor, maybe somebody else. But the point is, the creditor can't get money unless there's a distribution. And in many instances, that creditor can be tagged with the tax bill, right? With the income tax bill. So it's a bit of a poison pill. And so typically this causes the creditor to want to cut a deal with the debtor and settle. So there aren't a whole lot of cases on this in terms of like appellate cases. It's because the debtors and the creditors work it out rather than kind of go to Wyoming and say, hey, we want to crack open this close LLC. I don't think that's going to happen. Wyoming's a very small state, and I think they get a significant amount of revenue from this. So I think this is something that they take pride in and they want to protect. So let's go back to our example. Before Charlie's accident, Alpha and Bravo put their $1 million stock brokerage account into a Wyoming Close LLC. Alpha and Bravo follow all the applicable rules, create appropriate documentation, follow the formalities, pay their if they're California resident, they're paying their minimum franchise tax, right? And they generally respect the rules. This is not a set it and forget it. This is not a DIY project, a do-it-yourself project. When the creditor looks to seize the $1 million, right, or seize the LLC shares of Alpha and Bravo, it's those assets stay inside of the LLC, and the creditor is limited to garnishment of the distributions to Alpha and Bravo. So if there are no distributions, the creditor's not getting paid. And again, many times they get stuck with the tax bill. So again, another sort of poison pill. Well, how not to protect assets from outside liability. So there's a way to do it, and I'm going to tell you a way not to do it. So California LLCs, I can't even recommend looking at a California LLC to protect from outside liability. And this is why we have a solution for that we're going to talk about in a couple of slides. But California allows creditors to foreclose on a debtor's membership interest in an LLC with the use of court judgments. So this stinks. I mean, the legal term is it stinks for a single member LLCs that have no other partners to prevent the complete liquidation of the company, right? And for multi-member LLCs who want to distribute assets out. So it's really catastrophic. So if Alpha and Bravo put their $1 million portfolio into a California LLC, the creditor can foreclose on the shares of their LLC and get the entire $1 million. This does not happen with a Wyoming LLC. So that's why we choose Wyoming and not California. Well, how do we solve the California LLC problem? So I pitched this. I characterize this as a problem. It's a holding company. So when a Wyoming close LLC holds shares of a California LLC and acts as a holding company, so not an operating company per se, the shares of the California LLC can effectively get the charging order protection. And I'll say maybe, because an example here I'm going to talk about is a piece of property in California. California courts always have jurisdiction. If the dirt and the bricks and sticks are in California, a California court can make a really bad ruling. Maybe they can disregard everything and award that piece of property to a creditor. Maybe. So this is not guaranteed, but this is how it's designed to work. So I'm going to walk you through an example. Alpha and Bravo own Greenacre, which is a 25-unit apartment complex. The dirt, the bricks, and the sticks of the apartment complex are owned by a California LLC. So I just said California LLCs are terrible, but instead of the shares of the California LLC being owned by Alpha and Bravo, the shares of that LLC are owned by a Wyoming close LLC, and then Alpha and Bravo's living trust own the shares of the Wyoming LLC. So it's a little bit of like a bucket within a bucket, okay, within another bucket. So Alpha and Bravo's living trust owns the shares of the Wyoming LLC, and Alpha and Bravo now have charging order protection from outside creditors to protect their equity in Greenacre via the Wyoming Close LLC. So this protects you from outside creditors. If you have an inside creditor on the actual dirt and bricks and sticks that are located in California, I don't care what kind of asset protection plan you have in place, a court has jurisdiction to award that property to somebody else. Fundamentally, they've got jurisdiction over the real property. So setting the inside liability issue aside, looking at the outside liability, this is an effective way of keeping, if Charlie does get in that car accident, to protect this 25-unit apartment complex, right? That's a way to protect it. So if you're watching this on screen or YouTube, we have a holding company structure here. So you have the holding company that owns, typically these are taxed as a partnership. And even if you're a single person, 99% can be owned by your living trust, 1% can be owned by you, and you can file as a partnership. We typically recommend that these structures do their tax compliance as a partnership. All that stuff appears on the partnership return. All that garbage, for lack of a better term, all those numbers and all that data appears on a partnership return, not your own personal 1040, which has a higher risk of audit. So managers can receive compensation from a holding company, but the idea here is the Wyoming Close LLC owns all the shares of the other LLCs, which are disregarded entities typically, and you're not filing multiple partnership returns. You're filing one partnership return. Well, let's look at use of trust to protect assets from outside liability. The Domestic Asset Protection Trust. What is this? A domestic asset protection trust, also known as a self-settled spendthrift trust. That's a mouthful. That's a type of trust that is designed to permit the creator of a trust to be a discretionary beneficiary and still offer significant level of outside creditor protection of the trust assets. Now, many states have domestic asset protection trust laws in place, and there's 17 of them. We tend to think Nevada is the best. Many commentators believe Nevada is the best. Many of our clients end up moving from California to Nevada, which is a natural fit. Okay. But you do not have to be a Nevada resident to enjoy the benefits of a domestic asset protection trust located in Nevada. So they have requirements. There are 5 requirements. Number 1, the trust must be irrevocable. So what this means is you can't change it. You can't amend it. You can't revoke it. Irrevocable, kind of cast in concrete. You must not require the assets to be distributed to the creator of the trust. Now so if you set up this domestic asset protection trust, you can't say, hey, trustee, you must distribute income or income in principle to me. Since you're the creator, you can't have that. But you can still receive distributions if they're subject to the discretion of a third party. And typically this is referred to as a distribution trustee. And that individual can be chosen by the creator. So maybe it's a friend, maybe it's a trust company, maybe it's a business partner or somebody, but it cannot be related. The person cannot be related or subordinate to you, or an employee of yours. And that's under Internal Revenue Code 672C. The creator must also prevent a distribution from the trust. The creator can also prevent a distribution from the trust, saying like, no, I don't want you to distribute. Grant the authority to use real or personal property, maybe to others. Hold lifetime, testamentary, or limited powers of appointment, which is the ability to change who gets the property while you're alive or after you pass away. So you set up this irrevocable trust. You say, this is for me, and when I die, it goes to my kids. Well, if one kid needs it more than another, you can change who gets that when you die. That's not considered an amendment. That is not considered any sort of change in the trust itself. That is exercising something called a power of appointment. So best described as, or best understood as, the power to disappoint, right? So if it's going equally to your kids and you exercise your power of appointment, the kids who aren't getting or getting less are disappointed because they're getting less money. So hence it's the power to disappoint. Remove and replace trustees, direct trust investments. That's very important, and execute other management powers. So directing trust investments, meaning you might have shares of your company. Maybe you put those in the Nevada Domestic Asset Protection Trust, right? And then you're directing how the assets are invested. So there's a little bit of a time period involved before you get full creditor protection. So a creditor must file a lawsuit challenging a transfer to the Domestic Asset Protection Trust within 2 years after the transfer, or 6 months after the creditor discovers or reasonably should have discovered the transfer. So this is if it's a creditor, right? Now, this is where it gets a little sketchy, because you have this new voidable transfers, fraudulent transfers rule that says if you're a lawyer and you help somebody evade creditors, that lawyer is responsible 100% or 3 times the amount of the creditor. So typically, if they're clients of ours, people don't have any creditors. They're just worried about it in the future. They say, look, I really want to protect it from future creditors. I'm in business. I don't know what's going to happen. Things may go good. They may go bad. I may end up with a liability. So they must commence an action against the transfer within 2 years. So if you put assets in there, they're exposed for 2 years, but after that 2-year period, those assets are not available to creditors under Nevada law. And each time period begins when you put a new asset into the Domestic Asset Protection Trust. So it's not like opening a bank account and then 2 years go by and you can keep stuffing money in there or assets in there. Every time you put something in there, it's a 2-year clock that starts with respect to that particular asset. And that is step 3. The 4th requirement, Nevada does not recognize exception creditors. Exception creditors are creditors that can access assets in a domestic asset protection trust after the statute of limitations has expired for public policy reasons. So this would include, things like child support and spousal support. I will tell you that California has ethical rules where we cannot engage in planning that to thwart the payment of child or spousal support. So we don't do it in our firm because we believe it's an ethical breach. I'm sure there are other lawyers out there who don't believe that. So this is really to protect people's assets from sort of the dangers associated with being in business or engaging in activities that may result in a liability. So if you're a pilot, pilots, if you crash your plane, you're typically flying the plane to the scene of the crash or the accident. the euphemism. And, you may have personal liability on that. So it might make sense to have some type of asset protection in place. So Nevada is one of only a few states that does not have statutory exception creditors. So what about non-Nevada assets? You have to be very careful with this. So domestic asset protection trusts are not recognized in every state. So there's no clarity on which state will honor which transfer to a domestic asset protection trust. And this can be overcome through use of an LLC. So many times clients will put property into an LLC, and then the shares of that LLC will go into a domestic asset protection trust. So you can compare this a little bit to a Wyoming LLC. I guess the difference is the Wyoming LLC is going to be primarily for business type assets, because something to understand is when you use a trust, and I've seen some material online where they say, oh, you don't use an LLC, you can use a business trust, and that replaces an LLC. Well, the reality is in California, you still have to file your franchise tax, and banks don't do business with trusts. So trusts are designed to hold essentially capital assets and not do a whole lot of stuff. If you want to be engaged in business and getting loans and buying and selling property, an LLC is a more broadly recognized form. So really, they have similar attributes, but they're used in there's a nuance to them where they're used in slightly different contexts. So let's look at a Nevada domestic asset protection trust example. Alpha and Baker place $1 million portfolio of stock in a Nevada domestic asset protection trust and name Premier Trust, who's based in Las Vegas, as trustee. So we use Premier Trust a lot. When their son Charlie has his accident, the assets of the domestic asset protection trust are unavailable to creditors, right? Been 2 years. The current annual fee for Premier is $3,000 a year plus $100 each time there is a discretionary distribution. So if you say, hey, I need some, we need 500 grand to do something, they're going to charge you $100 for a discretionary distribution. And there's a link here to Premier's website, and we'll put that in the notes and in the on the YouTube page as well. So that'll be on there once it's on YouTube. How to protect assets from inside liability. Well, first, you're always personally liable for your own negligence, okay? So Oscar, the owner, starts a fire on Rancho Fuego that spreads and causes damage to a neighbor's property. Oscar needs to think about outside liability because he is always liable for his own negligence. But if it's an employee, then it's not outside liability, right? It's going to be contained. So very, very important to pay attention to that. If someone in your business does something that results in legal liability, the business is responsible under the legal theory of respondeat superior, which is a Latin term, right? Respondeat superior holds an employer or principal, you've signed a power of attorney, right? An employer or principal legally responsible for the wrongdoing or acts of an employer or agent if they occur within the scope of employment or the agency. So if Romeo, kills somebody that's not within the scope of his employment, then arguably, respondeat superior does not apply because that would be outside of the scope of employment. Courts then, so if they find that there's respondeat superior, courts apply the doctrine of joint and several liability when assigning damages. So basically the boss ends up holding the bag. So if your employee does something and you're the boss, you're holding the bag. That's why it's a good idea to think about an entity if you have employees out there. So Oscar creates Rancho Fuego LLC before buying the ranch, named Rancho Fuego. Rancho Fuego LLC signs a management agreement with RF Services, hence Rancho Fuego Services, a corporation that leases the dirt and barns from Rancho Fuego LLC. RF Service hires Romeo, the ranch hand, to do a controlled burn. The fire gets out of control. The neighbor sues RF Services, Rancho Fuego LLC, Oscar and Romeo. What's the result? The neighbor recovers against all relevant insurance policies. So there might be a variety of insurance policies, recovers against RF Services, Inc., and seizes all the assets of RF Services, which aren't a lot. Recovers against Romeo. He's got a truck and $68.13 in the bank. The neighbor does not recover against Rancho Fuego LLC or Oscar. This is very important to understand that what we've done is we've segmented the operations so that the capital asset is in an LLC, probably taxed as a partnership, and then the operations of the ranch are in a corporation. Now, it could be an LLC taxed as a corporation, but in this case, it's a corporation. And it's very important when you have multiple LLCs and naming LLCs, I would recommend using very distinct names. So sometimes people get in the habit of using, they might do 5 LLCs with the same word at the beginning. That drives your CPAs nuts. It's better to have distinct names because then you have less likelihood of having your tax returns, frankly, messed up. So without the LLC and the corporation, the neighbor could have recovered against Rancho Fuego LLC and Oscar 100%, right? Unlimited liability. So how can you protect a loved one's inheritance? Well, Alpha and Bravo create a revocable living trust. When the survivor of Alpha and Bravo passes, Charlie inherits everything. Charlie's inheritance is held in a continuing trust for Charlie's benefit. For the most protection, Charlie should not serve as trustee. So if Charlie's in trouble, and we know there's going to be a problem, it's best if Charlie never serves as trustee. But if Charlie wants to serve as trustee, that's okay. But the inheritance has slightly less protection, and a trust protector who has power over the trust but is not the trustee. So a trust protector, if Charlie's serving as trustee, the trust protector can remove trustee or remove Charlie as trustee and replace Charlie with another person or institution. And then that kind of puts a lid on it because there's a maxim, whatever you can get to, your creditors can get to. That's largely true. So if Charlie has a trust and he's the trustee, it's less creditor protection than if Charlie were not the trustee. That's different than Charlie resigning as trustee because this power of resignation, that's even, that's a little bit watered down from the trust protector, which is in many instances an attorney at our firm. That trust protector removes the trustee and puts somebody else in there. And that tends to have the best creditor protection. When it comes to IRAs, very large IRAs, it's very important to understand that an individual retirement account has zero creditor protection. It was a Supreme Court case from 2014, Clark v. Ramaker, and that held that 9-0, an inherited IRA. So mom and dad die, Charlie inherits the IRA, zero creditor protection, none. At some point under the IRA laws, all that money must be distributed out from the account, typically 10 years after the death of the person who has the account. And Alpha and Bravo can leave their IRA to an IRA legacy trust, naming Premier Trust as successor trustee. This is what many of our clients have done. Charlie's inherited IRA account then is held in a separate trust or in a special trust for IRAs for Charlie's benefit. This provides creditor protection and delays and can potentially eliminate state income tax on the inherited IRA. So if Charlie inherits a $5 million IRA, the state income tax may be $600,000, $550,000. Charlie can move to Florida, maybe, or move to Nevada for a couple of years, not be a California resident, and then take the money out of the trust and avoid the California income tax. Business succession planning, death, insolvency, and incapacity. So when you have a business, you need to think about death, insolvency, and incapacity. And we're going to look at an example here. Echo and Foxtrot have a company, Widgets R Us, LLC, that manufactures widgets. I don't know what a widget is, it's just a thing. They've created a profitable business that generates $10 million a year in revenue and $2 million in annual profits. So Echo and Foxtrot are making $1 million a year each. It's great. What happens if one of them dies or is forced into bankruptcy? What if one becomes unable to continue to work? What if one of them wants out? So these are things that happen when you are a business owner. And in this case, with somebody else, you're not going to do this forever. One person may want to continue with the business, the other one doesn't. What if somebody goes into bankruptcy? You have that car accident, your knucklehead kid gets in that car accident with the doctors and it's $300 million. Does that creditor become a partner with you, right? So if Foxtrot goes into bankruptcy, Foxtrot's trustee in bankruptcy is now partners with Echo unless they deal with this in the corporate documents. So this is extremely important. So if your business partner dies, you want to be in business with their heirs, right? The spouse, the kids. If your business partner files for bankruptcy, right? You're in business with the bankruptcy trustee. What about divorce? Do you really want to be, does Echo want to be partners with Foxtrot and Foxtrot's ex? I mean, imagine, trying to get anything done. What if your business partner strokes out, right? Becomes incapacitated? Do you want to be in business with the court conservator or their successor trustee? So very, very important. Documents involved in business planning, just on a high level. Powers of attorney, very important. Those powers of attorney, that's where one person delegates the power to another. That's where, if you're unable to do for yourself, someone else does for you. Some of these things that need to be done have to be done by a power of attorney, cannot be done by the trust for a variety of reasons. So very important component of an estate plan. Buy-sell agreements. So this is really important. This can be sort of baked in to the operating agreement or the bylaws, and oftentimes is a separate agreement. It just depends on the case, and we're going to go through 5 examples, and you'll see why. Non-disclosure agreements, very important, and general estate planning documents are part of it, including an appropriately funded revocable living trust, maybe an irrevocable trust, and other types of LLCs and entities as well that we've discussed. Well, there are 5 types of agreements, and there's a typo, but just ignore that. We're going to cover entity redemption, cross-purchase, cross-endorsement, wait and see, and one-way agreement. So entity redemption. This is where the entity, the LLC or the corporation, agrees to buy a deceased person's interest after death. This is often funded with insurance. So the example is when Foxtrot dies, Widgets R Us LLC collects a life insurance death benefit and pays it to Foxtrot's living trust. Echo ends up effectively with the entire company, right? That's what happens. So it's the company buying the shares of the deceased owner. Cross purchase is other owners agree to buy the shares of the other owner. So Echo individually holds a life policy on Foxtrot. When Foxtrot dies, Echo buys Foxtrot's shares from Foxtrot's living trust. So this is where Echo's buying the shares versus the company buying the shares. So if Echo owns 50% and Foxtrot owns 50% and the company buys Foxtrot's shares, it's kind of similar to Echo buying out Foxtrot's shares. It's just a different way to do it. And there are reasons why you would want to do one or the other. And this gets pretty granular in one-on-one. Cross endorsement. So the other owner agrees to buy. So again, this is the other owner agreeing to buy a deceased person's interest after death. Echo holds a policy on Echo. Foxtrot holds a policy on Foxtrot, each controlling their own policies. Each endorses or dedicates some of the death benefit to provide liquidity. And this is a form of renting. It's called renting life insurance. Very high level. You can dedicate some money to the buy-sell and use the rest for personal needs. And here's kind of how a cross endorsement works. Business owner A endorses the death benefit. Business owner B does the same thing. So they're really in the same spot. And then there's wait and see. This postpones the choice between an entity redemption and a cross purchase until the death of the business owner. So if you're like, gee, we don't know, let's just wait and see what happens. The equity owners agree to purchase a deceased owner's interest pursuant to the terms of an agreement, often involving life insurance. Now, again, we're not selling life insurance in our law firm, but life insurance can be a really big part of the buy-sell. Often the entity has the first option to purchase the decedent's interest. And if unexercised, then it goes to the other owners. But if the other owners don't want to buy it, then the entity must purchase it. So Foxtrot dies with a wait and see buy-sell in place. Either Echo or Widgets R Us purchases the shares of Foxtrot from Foxtrot's trust, but because they're 2 people, it essentially has a similar result. One-way agreement. So this is slightly different. So this is where one person might want to exit and one person stay on. So this is typically if one person wants to leave. A lot of times, this is part of a prearranged sale where you're going to sell to one or more co-owners. So a one-way cross-purchase arrangement requires the buyer to purchase the business owner's interest upon the occurrence of a triggering event. And the buyer purchases a life insurance policy on the business owner's life. So Echo would buy a policy on Foxtrot's life. The buyer pays the premiums and the buyer is the beneficiary. So the business can provide the source of payments through a taxable bonus to the buyer. So in this case, Foxtrot would be bonusing Echo to buy the life policy. At the business owner's death or departure, the buyer uses the death proceeds or cash value to buy out the departing partner. So Echo's young, Foxtrot's a generation older than Echo. Foxtrot wants to retire, so the company increases Echo's compensation through a bonus. Echo takes out a policy on Foxtrot's life, owns it, and uses the bonus money to pay the premium. If Foxtrot has a premature death, Echo can pay the premiums on to Foxtrot's living trust and then own the company outright. The Corporate Transparency Act, very, very important. The Corporate Transparency Act, and this is our last topic to cover, is a new federal law that requires privately held companies to identify to the Financial Crimes Enforcement Network, which is like it's a law enforcement agency, people, provide personal information about the owners to the federal government. This is designed to combat money laundering, tax fraud, and other corrupt activity by using corporate structures to shroud the perpetrators' identities. So this is designed to counter terrorism. There was a huge case of money laundering, the billions of dollars not that long ago involving Mexican drug cartels. So this is pretty serious business. It is effective 2024 for new LLCs and January 1, 2025 for existing LLC entities, which we're recording this in May. That is like tomorrow. So if you have an LLC, you might have to file, you might not. Check out our webpage. We've got a lot of information on it. We actually have a service offering for people who have this, who don't want to deal with it. It's really not that big of a deal, frankly, to do it if you just do it. But some people just don't want to bother with it, and we can certainly help you out with that. And frankly, some of them are more complex. So if you have a more complex structure, so if you have multiple trusts owning LLCs, it can get pretty complex. Is consulting with a lawyer enough? I think you need to assemble your A team, which is a specialized California trust and estate lawyer, CPA, financial advisor. At our firm, we handle business law matters. We have 2 attorneys on staff that are dedicated to business and real estate matters, as well as all the trust and estate and tax work as well. Your CPA, integral part. Many of our clients are finding that their CPAs are retiring, and they're like, who do I go to? And the same with their lawyers. Their lawyers are retiring, and that may be why you're watching this video, is because your advisors are retiring, and the financial advisor. So certainly when it comes to the buy, sells, and the insurance, you want to involve your financial advisor. And our book, Savvy Estate Planning, which is available from our website and also on Amazon. And we'll put a link into the YouTube video where you can buy a copy of that. We cover a lot of what we talked about here. If you're watching this on YouTube, please subscribe to our YouTube channel. And if you enjoy our webinars, please go to our Google, review us on Google. We really appreciate that. Next webinar is real estate investing, not in California. Kind of cool. We're going to have a special guest who is going to go over all things, not investing in real estate, but not in California. So California real estate, oftentimes the values are high. And when you look at the rents you're getting to the value, they tend to be very low for a variety of reasons. And we will be covering that next week. And we will open it up for questions. So if you're watching this on YouTube, please keep watching, because magically another video is just going to roll after this one's up. So thanks for watching.